For those playing legal terminology bingo at home, we have a new word of the day. First it was quid pro quo, everywhere you turned, and now?
Oh, that's hearsay.
There's hearsay.
That's right, hearsay. Press Secretary Stephanie Grisham also used the term to describe acting ambassador to Ukraine Bill Taylor's testimony when he said he was told Trump withheld aid to Ukraine in exchange for investigations into 2016 election interference and the Bidens. Grisham described it as, quote, just more triple hearsay and selective leaks from the Democrats' politically motivated, closed-door, secretive hearings. Yep, triple hearsay. And no, I don't know if there are extra bingo points for that, but Republicans say there's good reason for their skepticism.
This is a sham of a process.
Right now we're hearing one side of the story, and until we get the full picture, I said this yesterday, I think it's hard to draw any conclusions.
And to that end, Lindsey Graham told reporters today that he and Senate Majority Leader Mitch McConnell, they're planning to introduce a resolution to condemn the impeachment inquiry, urging the House to make the hearings public and allow for cross-examination, something Democrats are reportedly hoping to do by mid to late November. So, are the president's due process rights actually being violated? Is hearsay a real defense? And what about that Fifth Avenue thing? Joining me to discuss are Jennifer Taub, a professor at Vermont Law School and visiting professor at Harvard Law this semester. She's also on the board of advisors for the group Impeach Trump Now. Good to meet you. Thanks for being here. William Weinreb is former acting U.S. attorney, lead prosecutor of Boston Marathon bomber Dzhokhar Tsarnaev. He's now representing one of the defendants, several actually, in the Varsity Blues college admissions case. Bill, it's good to see you as well. Before we get to impeachment, can we talk about the effort by the Manhattan DA to get Trump's private financial records as part of a hush money thing? It involves this statement from Donald Trump.
I could stand in the middle of Fifth Avenue and shoot somebody, and I wouldn't lose any voters, okay?
Okay, so yesterday in a federal appellate court, his lawyer, his personal lawyer, the president's personal lawyer, referred to something called temporary presidential immunity. Here's the back and forth with the judge and the president's lawyer.
What's your view on the Fifth Avenue example? Local authorities couldn't investigate, they couldn't do anything about it?
I think once a president is removed from office, any local authority, this is not a permanent immunity.
Well, I'm talking about while in office.
No.
That's the hypo. Nothing could be done. That's your position.
That is correct. That is correct.
So what his lawyer is saying, forget this technical temporary presidential immunity, he's saying that not only can a sitting president not be charged, a sitting president can't even be investigated. Is there any merit to that at all or no?
Well, what's interesting is, no, there's no merit to that. And the clip you showed just after that, he was further asked questions by Judge Chin. Yeah. And he said that while the investigation could continue, he couldn't be prosecuted and he couldn't be subjected to any subpoenas. He couldn't be interviewed himself. And Trump's lawyer actually did say, for example, we're not stopping a grand jury, but they simply won't cooperate. They believe he has immunity from cooperating in any kind of investigation.
And it seems to me, forget shooting, which was the president's. I assume killing is included here. If he shot and killed that person on Fifth Avenue, the contention is you can't only not charge me, as I said, you can't even investigate me until I'm out of office.
Yeah, that's the argument. And there's no precedent for that in the law. So they weren't taking an established legal doctrine and trying to argue it. They're trying to make up something brand new and apply it to the president.
But even if they're trying to make up something brand new, if, for example, in the infamous Office of Legal Counsel memo that Bob Mueller relied on so dramatically, if the thesis for that is, listen, when a guy so far in our history is the President of the United States, he's got a lot of important things to do. You can't distract him with a prosecution. Couldn't I make an extension of that saying, well, if a prosecution is a distraction, an investigation is just a smaller distraction. So if you can't do one, according to the Office of Legal Counsel in the Justice Department you used to work in, why should you be able to do an investigation either?
Well, you have to remember, first of all, that memo, again, is just the opinion of one government employee. It's limited to federal prosecutions, and it has to do so. I think trying to stretch it to a state investigation is a big leap. Okay, so I have a ton of legal questions. Let's go down the list. The latest is the president's due process is being violated, the process is flawed, etc. Is there any merit to that? I mean, we know this is not a criminal prosecution. It's not even a prosecution. Is there any part of the president's due process that is not being granted by the Democrats?
No, and in two branches. First, the procedures the House is following right now are procedures that were put in place when John Boehner was in charge. And secondly, on your question about hearsay, as you know, this isn't a criminal process, but if it were, what we're talking about, what hearsay really is, it means an out-of-court statement used to prove the truth of the thing asserted. And what they're trying to argue mainly is that Bill Taylor, with his very damning testimony, that what he said, Ambassador Sondland told him about Trump, this is the key. The key to the quid pro quo.
They're trying to say the president say it across his own lips.
And they're saying that they're trying to argue that what Sondland said is inadmissible in this investigation because it's hearsay. But if you actually look at the hearsay rules, first of all, it wouldn't be considered non-hearsay because Sondland was acting as an agent for the president, who's the opposition. And even if it weren't considered non-hearsay, it would be an exception under the hearsay rules because if he's someone who made regular records of conversations he had in his job, then it could easily fall into one of the statutory exceptions. I mean, I'm not a criminal trial lawyer, but this is basic stuff law students learn. So it's a bit of a ruse. What they're really trying to do here is he's been caught red-handed. And so they're trying to deny, and they're trying to deflect, and they're trying to distract and spread disinformation, and it's just not going to work.
I want to get back to the process thing. You mentioned that the rules were adopted when Boehner was there. Let's go even further back. My understanding, this is exactly the way the Clinton impeachment hearings were conducted. It's the way Benghazi was conducted by Republican Trey Gowdy, who for a minute was one of the president's lawyers until it turns out there was a problem. This is the way things go, and ultimately, when public, there's an opportunity to cross-examine.
Sure.
Yes?
And for that matter, it's the way that every criminal prosecution in America works. You have a grand jury that first has to decide whether to bring charges. That's like the House voting to impeach. And then you have a trial. In this case, it would be in the Senate. When the grand jury is deciding whether to bring charges, they just hear from one side. There's nothing against due process about it.
I don't know if since you're two hot lawyers, you appreciate the same thing that I do. I love it when a legal term that 99% of Americans never heard before is now part of every American sentence. Everybody's saying quid pro quo, whether they know what it means, whether they can pronounce it or not. I don't want to get into that because obviously the Democrats are suggesting you don't need it, even though they are talking about it. The Republicans say you do need it, and there is no quid pro quo. I want to get into my favorite argument so far in defense of the president. It's from the Wall Street Journal editorial yesterday. It may turn out that while Mr. Trump wanted a quid pro quo policy ultimatum towards Ukraine, he was too inept to execute it. Impeachment for incompetence would disqualify most of the government and most presidents at some point or another in office. Their contention is, he's too inept to have exacted a quid pro quo. That's not even the law, is it? If it turns out, if a quid pro quo is necessary, if you attempt to exact one, you've satisfied the legal threshold, right?
Yes. And, a quid pro quo just means that there was an agreement of one thing in exchange for another. It's just a fancy way of saying that. You don't have to be very apt to make clear that you're expecting one thing in exchange for another.
But again, even if there wasn't an agreement, if he tried to exact an agreement, that's all he needs to do, right?
Yeah, this is a really crucial point, which is if you're looking at the federal bribery statute, a criminal statute, Section 201 explicitly says that if a government official, including the president, seeks something of personal value in exchange for an official act, that is a crime. It doesn't matter whether it's successful. And I think what the Wall Street Journal is trying to do here is avoid the bribery because, as you know, a similar word, bribery, a similar concept, bribery, is also an impeachable offense. So if you look at the language in the Constitution, it's treason, bribery, and high crimes and misdemeanors.
Or as Gerald Ford said, as a member of the House, or whatever we say it is in the House of Representatives.
But bribery is explicitly in the Constitution. So
treason, bribery, or high crimes and
Right.
misdemeanors. Can we step back for a second? You're a former Justice Department guy. Bill Barr, my understanding, is the Attorney General of the United States, not the personal lawyer for the president. He's gone to Italy and other countries in an attempt, and now he's working hard, in an attempt to suggest, forget that 17 intelligence agencies said the Russians interfered, that essentially our allies worked with deep state enemies in the United States to assure that Donald Trump wouldn't be elected in 2016. The argument goes, if I'm able to prove that,
the Bill Barrs of the world, then it will be a great predicate for the 2020 election, basically saying you have to defeat that deep state. Does it trouble you as a former Justice Department official, regardless of what side you're on impeachment, that the Attorney General of the United States is engaged in such an effort?
If he's doing it for political reasons, then absolutely. DOJ has always been non-political, and there's no exception just because the president is interested in something. On the other hand, it isn't unusual to seek assistance from other countries in criminal investigations, and if there's a legitimate predication, as they say, for this investigation, then he'd be within his rights to do it.
30 seconds. Do you have any problem with it?
Look, I think Bill Barr needs to focus on the main thing at hand and recuse himself from the Ukraine investigation, because he's named in the phone call that the White House released what the president said is work with Bill Barr. So that's really what we should be focusing on.
Before we go, just in 30 seconds, I introduce you as having been the lead prosecutor in the Tsarnaev case. So you know an appeal is being made of the sentence, arguing that you and your colleagues are appealing to Islamophobia, that a couple of jurors lied about their bias. There was a failure to disclose to the jury the alleged involvement of his older brother in a triple murder in Waltham. Can you give me a quick reaction to their appeal?
Yeah, you know, all of those arguments were made at the trial. There's nothing new here. This isn't like some new discovery that just came to light. The judge in the trial, who was a very fair judge, very good judge, considered these arguments and rejected them. I don't see anything new that's being said that would lead to a different outcome.
Bill, it's nice to see you.
Yeah,
Thank
good
you so
to
much
see
for
you
your
too.
time. Pleasure to meet you too, Jeff. Thanks.